The next issue is the question of regulation for the third-party industry, again thrown up by the Jackson report. And the areas where regulation is talked about are capital adequacy of funders, circumstances in which funders can withdraw from claims, and the whole issue of adverse cost, which we've touched on already. Gavin, if I could start with you, just from a practitioner and a client perspective, do you think we need regulation, and what form might it take?
I think I welcome voluntary regulation, self-regulation, because I think that's a sensible place to start, as Lord Justice Jackson outlines. However, I think compulsory regulation is inevitable in today's world of increasing regulation, and I think that will just happen in the medium to long term. I think the first scandal involving a third-party funder, either they go bust or they pull out of a high-profile case, will just move it up the political agenda. But I don't think it's realistic to expect that anytime very soon.
Right. Kerry, do you agree with that?
Yes, I think there needs to be protection for the client, whether it's, I don't see why commercial clients shouldn't be protected in the same way as anyone else, whether that's by a maximum percentage take, I don't know, but I think that does need looking at. The problem with circumstances in which funders can withdraw funding, it's the old saying, he who pays the piper calls the tune, and I would be unhappy as a funder about not having a great deal of freedom to withdraw from the case, just as when I'm doing conditional fee work, which is, it's not financial funding, but it's funding with my staff and resources and time. So I think it's very difficult to prepare a set of rules as to that. As for capital adequacy, that I'm afraid is a statement of a man totally remote from reality. Capital adequacy, if you have a stock market and you have floated companies, remember law firms are being deregulated from October the 6th, so we can be, my firm's a PLC, then I'm sorry, it's the stock market, it's not the law that governs that, it's the Companies Act. Claims direct was apparently capitally adequate. What you may move is towards a sort of bonding system, but the problem there is on relatively small numbers, funders by definition on the areas we're looking at the moment, ignoring the mass market, are funding cases where the client presumably has had difficulty in funding themselves or taking it on. To say to a funder, you not only have to fund the case, you are going to have significant capital provision, you are potentially liable for all of the adverse costs, and you will not have the right to withdraw from the funding except on very limited circumstances. Seems to be wholly unrealistic. The Australian courts have said the opposite, you're not liable at all, third-party funders. And that seems to me a more realistic model. I don't see why a third-party funder enabling a claimant to bring an action should, by that fact alone, be liable to defendant. I don't see the logic of that in a free market. Whether you like a free market or not is a different issue. I just don't see the logic of that.
I'm going to come to Susan and Neil last on this one. Malcolm, do you see regulation coming in what areas?
I think regulation is inevitable eventually. I don't believe that self-regulation is actually going to be the answer, because I think it will encourage other people to come in. And although I'm very happy about the funders who already exist, self-regulation I don't think is going to have the sanction to deter the cavalier or the maverick entering the market, and I think that's why regulation will come. But I think some form of light touch regulation is desirable, but I think we should also remember that we already have it in a sense, because the courts have actually wide powers. They just choose not to exercise them, and maybe that's perhaps where sort of case management should look at what the funding arrangements are and get involved, rather than sort of leaving it till the end. But I am also conscious that when that did happen, and Oasis was the case where the litigation funder actually went to court to get approval, and he got approval, only to find 4 years later it was null and void. We have to know exactly where we're going. The capital adequacy, I think, is an issue that is not properly understood. I'm an accountant. I have great problems understanding what people are talking about with capital adequacy. The accountancy profession has great problems understanding even how to account for contingent liabilities and so on. And the idea of having an unlimited liability for adverse costs and an unknown cost, what figures do you actually put on your balance sheet to define what sort of capital levels you actually need? And I think that's the real issue. It's very nice to be able to say we think we're adequate on capital because we, for example, reserve the same amount as we're prepared to invest in this case for adverse costs. But adverse costs could be considerably more than that. If you look at a regional claimant lawyer taking on a big London firm, you know, there's no relationship necessarily between claimant and adverse costs. So what level of capital is adequate? And if you look at the academic press, there's been a tremendous amount of discussion on insurance companies on that type of question. Insurance companies go bust, banks go bust, litigation funders will go bust. It's inevitable, and that, I'm afraid, is going to be the reality.
Angus, do you want
I think I agree, and I think I'd also say there is probably a distinction to be made between self-regulation of the reputable third-party funders who are capitally adequate, if that's a correct phrase, and the new entrants to the market who aren't. Probably not the reputable firms that we're talking about. I'll use the word grubby again. The sort of grubbier end of the market, and in fact, not even the grubbier end of the market, a grubby, different market, I think we're talking about. And I think that what regulation needs to do is it needs to control those entrants, not just in the interests of protecting the consumer, but also in the interests of protecting the industry and the funders who already exist. Because I agree entirely, it's only really going to take one bad case or one funder, another claims director or the accident group, and the whole industry is then probably going to be subject to heavy regulation, which may not actually be needed to control the actions of what we're effectively talking about are rogue traders. So I think it's inevitable.
John, do you agree with that?
I mean, I do, yes, yeah, and that's my view. I mean, when I was doing the research, a lot of the funders were involved in the cross-industry group to devise a code of voluntary regulation. I mean, everyone was sort of telling me that there was no issues on capital adequacy or kind of cover for adverse costs, but it's interesting to hear what Malcolm had to say. I wasn't aware of there's that degree of complexity around it. But I do think that we're talking about two separate things, and the pressure for regulation is going to come from the consumer stuff. But
I think just one point to add to that is what I think is often overlooked, because when we have our gatherings at the Civil Justice Council to talk about these things and to contemplate what's the way to go, the role of the solicitor, despite Kerry saying they're all going to disappear on October the 7th, there might be some left, is that it's the role of the advisor to the client. In the same way, if you are buying or selling a company and you've got warranties and indemnities, it is the solicitor's role to ensure and advise their client that those have got money behind them. Otherwise, they're pointless. It is also the role of the solicitor when advising their client about whether their case A is any good for funding, B, whether the funder is any good for the funding. So let's not absolve the advisor from this role, which is critical at the heart of all of this, that they make sure that the funder that they engage their client with is the right one. Yes, regulation, and I think it is inevitable. We'll see more formal regulation. I don't have any problem with that. We're already regulated as solicitors running the company, FSA authorised running the company. I don't think any of that will be difficult given the way we run our business. But let's not forget the role of the advisor.
I'm not saying that solicitors disappear, solicitors' firms will disappear. I think it's a very big factor because I will run a third-party funding company. It's unregulated. I run one effectively now. And solicitors, the entrepreneurial solicitors, we're setting up an estate agency. I'm doing a course on solicitors setting up estate agencies. I don't think solicitors will disappear, far from it. I think solicitors will start running all of these parasitic, I don't mean that in an unpleasant way, I mean they will start running claims management companies, third-party funding, estate agencies, insurance companies, that once October the 6th has passed, it will be seen as a liberation for lawyers. But lawyers, they run, we run every country in the world, every Prime Minister and President's lawyers. We will simply move into these other areas. So I've almost become a Legal Services Act convert in that sense. The problem here is that solicitors who move into those other areas on the 6th of October will be far, far less regulated than we are now. And that applies to everything else, third-party funding, insurance and so on. far less regulated. And don't kid me that FSA regulation is a tenth as tough as Solicitors Regulation Authority regulation, because it isn't.
I think we've got to remember one other thing as well, and that is the face of funding has changed. We have claimants who are impecunious, and that's perhaps appropriate then to discuss whether funders should be liable for unseen adverse costs. And we have claimants who just want to transfer litigation risk away, who are quite capable of paying the costs, but have decided they don't like the litigation risk. So they come to a contract arrangement with a funder as to what risk they're transferring away. And those are very different scenarios, I think, for considering whether one should automatically have a liability for adverse costs or this capital adequacy. The requirements would be different in those circumstances, I feel.
Neil, can I just ask you, and this issue about funders being able to withdraw funding, you've had some strong support from Malcolm that it would be a nonsense to curtail you in that way. Do you understand the concerns on that? I mean,
yeah, absolutely. I mean, from our point of view, we think it's right that the funder should be able to retain some level of control about whether they fund, and it's not really in anyone's interests to bind a funder into pursuing a piece of litigation which the funder has concluded isn't worth it, because it probably is, that case is going to be a losing case. It is uneconomic, and there's no benefit to having that funder to the court. So it's important that the funder is able to control that. That's also important for investors. And there's a legitimate purpose to regulation here, which is to help nurture a nascent industry as well as protect the client. And the regulation needs to do both of those things. I think that the self-regulation and light touch regulation is probably the best way forward, and it's flexible. As far as whether funders should be able to withdraw in particular circumstances, that's probably something that needs to evolve over time. The way we do that, we do retain extensive controls about whether we are able to withdraw or not, but there are consequences for us withdrawing, and we think that's a fair way of doing it. Best practice will evolve over time.